It's getting set up.
I'm gonna leave and come back in, because this is a disaster.
Okay, it should be up on YouTube at this point.
Yeah, there's a note on my screen that says it's now streaming live on
Yeah.
YouTube.
Yeah, okay, good.
Here it is.
Right, so if you close the screen, how do you get to it? I think it's behind the screen. Can you close email?
There's Joan.
Here we are. Why don't you subscribe?
There. Come on. No. Where are you moving?
That's because we haven't made it yet. So on my other computer, it says that we have no content on our website. Is that, am I in the right place on YouTube?
Yeah,
No.
'cause I deleted the test thing that we did last night, and I made the thing that I had done before private because I was trying to edit out the beginning and the end, and it ended up kind of weird. And I was going to ask Mickey for help with that.
Okay.
Okay, but right now, if you go to YouTube, Jean said that she got a note that said it's now streaming live. So it must be
Yeah, it says on my screen it is.
I do not think it was a high point. She did not draw as much out, for example, as Senator Harris was able to do against Bill Barr.
Oops, somebody's TV.
Somebody has their TV on.
Is Jack Epstein?
The takeaways I have.
Can you mute him? There he goes.
Okay, I'm going to set it to public if you want. I deleted the very beginning, but there's a little bit at the end still. But so now when I save changes, do you see it?
I have it in the other room. But I don't, yeah, well, it should be live streaming.
Okay, so under channel videos, we have data-driven climate change in North Redondo Beach, Artesia corridor, 45 minutes. So that's public now. And then I also see a live thing, which is right now.
That's us right here.
Let's need to see him. All right. I've got it. Good
Okay.
time.
See, that wasn't so hard. We just took a while. Yeah, I don't know why we're using two different. It would have been easier if we used the same email for both of them, but we didn't. Took that extra step.
You need more light too. You need to turn that light on. Just turn the light on.
Ruth, did you see the chat?
I no, I didn't. But it says, thank you for remembering. I can't unmute. Yes,
from-
I'm not allowing, but nobody's should be muted yet. I haven't muted anybody.
Okay, so once it starts.
What we're gonna do is, once we get started, I'm going to mute everybody except for the Joan and then the four speakers and Jean, who's gonna run the chat. And that's how we will control things.
Perfect.
Okay, but I didn't want to do that because I thought before we got started, people might want to say something.
So do we want to, Barbara, start at 7:05?
I thought you were going to introduce the meeting.
Well, I am. I guess the question is, do we want to allow a little time for other people to join in? Or do we want to start right at 7?
Well, whenever we start, that's not the issue. The issue is you'll start and I'll go immediately after you.
Yeah.
Exactly.
Your class today, honey?
Yeah.
Well, this is the second time I've seen Richard today in my Omnilore class.
Oh, I see Vanessa's dad. How are you doing?
Hey,
Can you hear me?
Who is that?
Oh, I see your dad too.
Oh, there's Betty Gooden. I haven't seen you in a long time. It's Ruth Hart.
Hi,
Hi, how are you?
I'm fine.
Good.
And there's June.
Hi, Kay.
Hi, how are you?
Good.
hi, Renee. Barbara and
Hi.
Rich Riley.
Hi.
Okay.
Well, did people listen to the confirmation hearings for the justice today?
Some of it.
That wasn't the issue. The issue is that the Supreme Court ruled against the census.
Yeah.
That's the issue that's important. You
Well,
know,
they-
justice
no.
is going to be automatically confirmed. But
Yeah, they actually, it's kind of interesting because what the Supreme Court did was somebody said it's going to be like Bush v. Gore, is that they just temporarily halted it until the litigation is finished. But
Right.
of course, by the time the litigation is finished, it might be a problem. But I actually went on to the census site after that, the census.gov, and it gives you the percentage of completion rate of households for every state. And I'm not sure I trust their numbers, but except for Mississippi and I think Alaska, they're all at 99.9% complete.
Really, that's incredible.
Yeah, the reason I'm not sure I trust it is that they have the percentage of self-reporting, people filling out their own census, and then the proportion that was contacted after that time was ended.
Oh, I got it. Right.
And it together it adds up to
Got
99.9.
it.
But you look at California's at like 69% self-reporting, which was quite high. It was well above average and in fact, most of the blue states were above average for
I'll still push
self-reporting.
for it at all our meetings. So
Yeah, I mean, it's interesting to look at the data.
This is on the census.
Yeah, the census.
You didn't get answered tonight, you can reach out to my office at 213.
Oh, somebody needs to mute themselves.
Looks like we have at least 6 people now watching on
On YouTube?
YouTube.
Oh, cool.
So well done, Ruth.
Well, I didn't do anything. It was Grace who set up the channel. All I did is she figured it out. We'll see how to get that connected. So And we needed your cell phone too.
And Diane Wallace joined us. Hi, Diane.
Hello.
Well, do we want to get started? Yeah.
Sure. So let me say before you introduce it, I am now going to mute everybody and then unmute the people who are going to speak. And that will take about 30 seconds. So I'm going to do that now.
And if people want to make comments, there's the chat.
You're muted now. So, okay. Barbara gets unmuted. Come on. Hold on, this is not working to unmute Barbara. Okay, now. Let me try. Who else? Jean. Okay, this is not working, so I'm going to unmute everybody. And if everybody who's not going to speak can just mute themselves, and we'll hopefully everybody will be on their best behavior.
I don't know. We'll try.
That's good. So welcome, everybody. I'm Joan Lesage, and I'm president of the League of Women Voters of the Beach Cities. And the League and the 19th Amendment, giving women the right to vote, are both celebrating 100-year anniversaries. Since then, the League has focused on ensuring that all citizens are registered to vote, and then we have fair elections. We believe it's critical that voters are educated on the facts and then vote. Therefore, we hold these pros and cons forums like this one to discuss the propositions. For candidate information, we support votersedge.org, which has all the candidate races plus the judicial races, where you can compare candidates side by side with information that the candidates themselves have provided. I'm going to salute our members and thank them and everyone who is on YouTube, which is new for us. Thank you for joining us there, and everyone else who is on Zoom. You've joined us tonight because you understand the importance of being an educated voter, and we salute you for that. And with that, I'm going to turn the program over to Barbara Arlo, who is our past president and voter services chair. Many thanks to her and the many other volunteers who have worked long hours to make this program possible. So Barbara.
Thank you. There are 4 propositions on this. Actually, there are 12 propositions on the ballot. 4 of them were placed on the ballot by the state legislature. 7 were placed by supporters who gathered sufficient signatures based on the previous election and seek to make changes in state laws or the California Constitution. To be included on a ballot, a constitutional amendment initiative requires a petition to be submitted to the Secretary of State with the certified signatures of 8% of the total vote for all candidates for governor at the most recent gubernatorial election. One of the propositions is a referendum. that seeks to overturn an existing law, and that was placed on the ballot by supporters who gathered sufficient signatures. One proposition, number 14, is for bonds. Bonds money is used for capital projects, mostly brick and mortar. General obligation bonds are sold to investors and repaid from the state's general fund over approximately 35 years. Interest rates are about 2 times the amount of the bond. The 4 speakers we have tonight are Ruth Hart and Terry Newstetter and Renee Campbell Labriola and me. That's the 4 of us. And we're going to start with number 14, and Ruth is going to present number 14.
Okay, as Barbara said, number 14 is the only bond issue on this year's ballot, and it has to do with stem cell research. In 2004, we had a proposition number 71, which changed the Constitution to allow for stem cell research, and it also created the California Institute for Regenerative Medicine, and the state sold $3 billion in bonds to fund grants for that institution. And at this point, that was in 2004, so that was 16 years ago. And at this point, all that money has been spent, or almost virtually all this money has been spent. And so the purpose of this initiative is to replenish the fund. And it would allow the state to sell $5.5 billion in new bonds to continue the funding for this institute. And the purpose is to advance medical research, especially in areas such as Alzheimer's, Parkinson's, areas where stem cells have a lot of potential. And those would be sold over 11 years, the $5.5 billion. So that's about $540 million a year. And it would make some administrative changes to tighten up the running of the Institute. The total costs are estimated to be $7.8 billion over a 30-year period. So they're being paid back over 30 years. And that includes $5.5 billion in principal and the rest in interest. Interestingly, total bonds, you know, we hear this, but total bonds are only about 4% of the general fund revenues. It's really not a very high percentage. And if this were passed, it would add another 0.2% to that. So it would bring it to 4.2%. The supporters say that stem cell research is important. It's led to significant advances in treatments and cures for many diseases. It's supported by over 70 patient advocate organizations, and especially in terms of Parkinson's and Alzheimer's. The opponents say that at this point, there are a lot of private organizations being funded by venture capital that do the same kind of thing, and so it's no longer necessary. And there have been some issue about the management of the Institute. So the supporters have raised, as of today, as of this afternoon, almost $8.5 million in funds. And the 2 main contributors to this are individuals who I'm not familiar with, Dagmar Dolby, and I don't know if that has anything to do with Dolby Sound, and Robert N. Klein II. And they've each given a little over $2 million to out of the $8 million funding. Hardly any money has been expended in terms of no's, only $250 from the California Pro-Life Council. It's supported, as I said before, by many health organizations. It is opposed by the California Pro-Life Council, but also the LA Times has come out in against this one. So that's Proposition 14.
I forgot to mention that Gina Hamilton, if you have any questions, if you'll send them to Jean, she will ask the questions for you. Are there any questions on 14? Jean, do you have any questions on 14?
No.
All right, thank you. Then we're going to go on to 15, and Renee is going to do 15. Renee, are you muted? Can you unmute?
No,
There you go. Is that you?
she's not, we're not hearing her.
No. Anybody figure out what's happening?
I've had problems before where I've had to restart my computer with,
What we're going to do
Not getting
then
much sound.
is we'll see if Renee can come back on. We'll hold 15, and if not, I'll present 15 later on. But let's see if we can get Renee back on for that.
it says she's muted. I'm gonna unmute if I can. No, it's not letting me do it. I'm gonna unmute everybody. So
That's you, I heard you.
Yes, Ruth, whatever you did, it worked.
Thank you, Renee, that's great.
okay.
Okay. Proposition 15, that's increases funding for public schools, community colleges, and local government services by changing tax assessment of commercial and industrial property. The question here is, should the California Constitution be amended so that most commercial and industrial property is reassessed on a regular basis? Our current situation is that we have Proposition 13, and it caps the tax rate at 1% of the assessed value. A property is reassessed to market value when it's purchased or when ownership changes hands. After that, the assessment value can be increased by no more than 2% per year. Now, remember, I'm talking about the current situation. Because the value of property has typically increased much faster than 2% per year, the assessed value of most property in the state is less than its market value. This is particularly true of commercial and industrial property, which changes ownership less frequently than residential property. The 1% tax is used for the counties, for local governments and schools. Proposition 15 would require that large commercial.
I knew that's what it was.
Somebody is not muted.
Proposition 15 would require that large commercial property be reassessed to market value on a periodic basis. Proposition 15 does not change the rules for assessment of residential property, both owner-occupied and rental, and farm property. If all the property owned by a business has a fair market value of $3 million or less, that property would continue as before. Reassessment of large commercial property would be phased into starting with the year 2022 through 2023 tax year. A small business, and that's fewer than 50 employees, would not pay any tax on personal property. Other businesses would not pay taxes on the first $500,000 of their personal property. The money for local governments, 60% would be distributed according to an existing formula. 40% of the money would be allocated among schools, districts, and community colleges according to an existing formula. The fiscal effects of this, the Office of the Legislative Analyst of California estimates that Proposition 15 would produce about $6.5 to $11.5 billion per year for the years 2022 through 2025 in additional property tax revenues for local services. Supporters of Proposition 15 say that if Proposition 15 will provide billions in new revenue for our communities and schools. 10% of the wealthiest businesses will provide more than 90% of the revenue. It gives tax breaks to small businesses to help our economy grow. And it keeps Proposition 13's protection for homeowners, renters, and farms. The supporters have raised $6,700,000, the largest of which was Chan Zuckerberg Advocacy at $300,000 and Pacific Gas and Electric for $270,000. Opponents for this, Proposition 15, are concerned that Proposition 15 would trigger the largest property tax increase in California's history. Additional costs will ultimately raise prices for consumers. It will make it harder for people to start small businesses and will require huge costs to administer. There was no information on the funds raised for the opponents of this. But I can tell you that the former LA Mayor Antonio Villaraigoso is an opponent, along with the Republican Party and AMVETS of the Department of California. And that's it, unless there's some questions on this part of it.
I have a comment, though. I checked today on Voters Edge, and the supporters have now raised $47,893,619, and the opponents have raised $37,475,388 as of today on Voters Edge.
Thank you. I did not relate those numbers. Thank you, Barbara, for stepping in on that.
Jean, did you find any questions?
No, if you have a question, you can put it on chat so that I can see it. I'm going to screen them. But this lady has her hand up. I see this one lady with her hand up.
Okay, while we're waiting for her to do, you're going to put that on chat now, Amy? She's putting it on chat, she said. Just for a second, I'll add that a yes vote means that property taxes on most commercial properties worth more than $3 million would go up in order to provide new funding to local governments and schools. And a no vote means that property taxes on commercial properties would stay the same, and local governments and schools would not get new funding.
I'm not seeing any question if you want to go ahead.
I haven't done chat questions. I don't know how to send it.
Just do enter on your computer.
There's a chat down on the bottom.
I see that, and I did.
But click on that, and then
just hit enter.
Yeah,
enter.
Enter.
Hit enter.
Okay. Let's see.
Or return.
Yeah, we do have one question up, and that is if 40% of the funds go to schools, where does the other 60% go?
Local governments.
City and county governments.
It would be along the lines of libraries, community colleges, parks, infrastructure maintenance, and things of that nature.
It's the regular formula for how the money is dispersed. Nothing changes. The 60% it goes to the existing formula for local governments that's in existence now. And the 40% would be allocated among the school districts. The percentages have not changed at all. The distribution would be the same.
Okay, there's one more question that's been asked, and that is, how do our real estate taxes compare to other states?
They're much lower.
It depends on the communities. I know in New York, they're taxed for their schools. And so in each school district, so they have extremely high real estate taxes. So it varies in different places. California is amongst the lowest in the country. Are we ready to go on?
I don't see any other questions.
Okay, Terry is going to present number 16.
Right, Amy, I think.
Yeah, I did send it, so I sent it to.
Okay, it hasn't popped up. Just go ahead and ask.
But here's my question. It's very simple. Does this new proposition close a tax loophole? That's what I had heard, and that it doesn't really affect private individuals. It affects businesses.
Yes, it only affects the large commercial companies like Chevron and like Disney, who are still paying 1% because they don't leave the country, they don't sell their properties. It does not affect small businesses. It does not at all affect any residential property, whether you live in it or you rent it out to other people.
I had heard that especially large companies can sell to their shell companies, and in doing so, they can evade taxes.
Everything that people will do anything to evade taxes. You know about that from the federal government now. And to stop, the fact is that proportionately you pay more money than a lot of super wealthy people. That's not going to change. They will do anything to get out of paying taxes.
But it is true. The point is that Disney and Chevron have owned those properties since, forever. And so their assessed value has not gone up since 1978. And they're paying 1% plus 2% a year of that. I benefit from it. We bought our house in 1976. But most most residential property does turn over faster than commercial property. So.
Okay, thank you. We're going to go on to 16. Terry is going to present 16.
And Proposition 16 allows diversity as a factor in public employment, education, and contracting decisions. This was put on the ballot by legislature. It is a legislative constitutional amendment. So here's the question. Should California and local government entities be allowed to consider diversity as a factor in public employment, education, and contracting decisions? So as an overview, it would allow people to allow governmental decision-making policies to consider race, sex, color, ethnicity, or national origin in order to address diversity by repealing constitutional provisions prohibiting such policies. There is really not a direct fiscal effect on state and local entities. There could be in the future, depending on what decisions are made, but this is really about what was known as affirmative action. So to give you a little background, California and federal constitutions provide equal protection for all people, and everyone must be treated similarly. Before 1996, California and local entities had policies and programs intended to increase opportunities and representation for people who faced inequalities as a result of their race, sex, color, ethnicity, or national origin, and these were called affirmative action programs. For example, some California public universities considered race and ethnicity as factors when making admissions decisions and offered programs to support the academic achievement of those students. There were also employment and recruitment policies intended to increase the hiring of people of color and women. But in 1996, California voters approved a new proposition, Proposition 209, which basically banned the affirmative action policies. After voters approved this, the policies and programs were discontinued or modified unless they qualified for some kind of exception. An example would be when a race or sex was part of normal operations. For example, California might consider specified characteristics when it is required to receive federal funding for a contract using such businesses as being owned by women or people of color. Now, after 1996, some of the public entities created or modified policies and programs to instead consider characteristics not banned by Proposition 209. Some universities provided outreach and support to programs for students who are first in their families to go to college. Also, in making admissions decisions, they may make considerations on which high school they went to or where they lived to help with those decisions. So almost skirting the points that we mentioned earlier. So what is happening now is that the legislators would like us to consider Prop 16 repealing Prop 209, which would reinstate the affirmative action policies. As a result, state and local entities could establish a wider range of policies and programs so long as they with federal and state laws related to equal protection. So the pro argument would be Proposition 16 expands equal opportunity to all Californians, increasing access to fair wages, good jobs, and quality schools for everyone. It fights wage discrimination and systemic racism, opening up opportunities for women and people of color. Despite living in the most diverse state in the nation, women and people of color currently are still discriminated against. And there's the feeling that we are at a historic moment and need to strengthen California by overturning discrimination in all areas. Proponents or opponents say that approving Proposition 16 basically would be a step backward, that we would be introducing a new form of discrimination, basically trading it off to favor politicians' favorites of what they would like to see used. They don't want to see stereotypes of minorities and women that can't make it unless they get special preferences. They don't want us to focus on that. And they feel like there would be additional costs as this affirmative action comes back into place. They can't enumerate what those are, but they feel like there will be some kind of bureaucracy or red tape having to get through. A lot of money has been spent on the proponents. $17 million has been spent supporting this proposition, voting it yes. And a vote yes on this measure means that state and local entities could, that doesn't mean that they have to or that they should, they could consider race, sex, color, ethnicity, and national origin and public education, public employment, and public contracting to the extent allowed under federal and state law. A no vote on the measure means that the current ban stays in place and nothing really changes. And that side of the argument has spent a little over $1 million trying to keep things the way they are. Some of the key supporters are the ACLU and California Teachers Association. And then there are the Asian American Legal Foundation, Students for Fair Admissions really would not want to see things changed. Any questions?
No questions have been submitted, so.
Okay, then we're going to go on to 17. Terry is going to do 17 as well.
All right, so Proposition 17 restores the right to vote after completion of prison term. It is a legislative constitutional amendment. It's put on the ballot by the legislature. So the question is, should people on parole in California be allowed to register to vote and vote in elections. So what we're asking is, can we restore voting rights upon the completion of a prison term to the people who have been disqualified from voting while serving that prison term? So when someone is in prison, they can't vote. But when you are done with your, and there's some semantics around this, when you are leaving prison and you are on parole, it's usually about a 3-year situation, and you can't vote. Some people see that as the continuation of the term, and that's what the con side of this says, is that's just a continuation. But there's about 50,000 people that are in this parole every year. And so if this were to be restored for those people that are at the end of their sentence, that fiscal impact would really be less than 1% of the budget. It would be kind of startup costs for getting these people registered to vote and getting more people on, getting their ballots and all that kind of into the system. Right now, California Constitution prohibits people in prison or on parole from voting. The people who are in county jail or supervised by county probation are able to vote. This ballot measure would still prohibit people in prison from voting, but would allow those on parole to vote. State parole generally supervises for a period of time those who serve for serious and violent crimes. So what we would be doing is amending the California Constitution to restore voting rights to those people who have been disqualified while in prison. Those eligible to register to vote may also run for elective offices if qualified. And if this passed, those on parole would be able to register to vote and participate in elections. The pro side of this argument says yes to restoring a citizen's right to vote after they finish their prison term, aligning California with other states. I believe there's about 19. A recent parole commission report found that citizens who complete their prison terms and have their voting rights restored are less likely to pursue or commit future crimes. It's also a way to get people re-engaged with their communities. And usually of those 50,000 Californians, if they are able to find a position, a job, they're already paying taxes again, local, state, and federal levels. So we would, want them to be able to vote. The opponents say no, that we don't want this amendment to the Constitution because it grants violent criminals the right to vote before completing their full sentence, including parole. It allows criminals convicted of murder, rape, and child molestation to vote before paying their debt to society, and it denies justice to crime victims. So if you vote yes, you're voting for people on parole to be able to register to vote if they are 18 and residents of California. And no vote would mean that you would keep things the same, that they would still be unable to vote. Not much money has been spent on the con side, but on the pro side, about $1 million has been spent by the ACLU, the Brennan Center for Justice.
Are there any questions, Jean?
No questions have been asked.
Okay, then Terry's still.
Let me get a drink here.
All right, she's going to do 18.
So Proposition 18 is also put on the ballot by the legislature. It amends California Constitution to permit 17-year-olds to vote in primary and special elections if they will turn 18 by the next general election and be otherwise eligible to vote. So should 17-year-olds who will be 18 by the general election be allowed to vote in the primary special elections in this election cycle? Again, this proposition is similar to 17 in terms of the costs that would be incurred in getting kids set up early and getting their names on the ballot. I think there are about between 105 to 110,000 people that are in that 17 to 18-year-old range that might be considered. So I think you all know, but in even numbered years, California holds 2 statewide elections, the primary and the general election. In the primary election, voters determine which candidates will compete in the general election. Statewide ballot measures may also be considered at both of these elections. In addition, there are special elections to fill vacancies and local government elections to elect local office holders and consider local ballot measures. In California right now, in order to vote, an individual must be at least 18 years old at the time of election. A person may pre-register to vote at 16 or 17 years of age, and we've done a lot of that at the high schools here. And then they are automatically registered when they turn 18 years old. Proposition 18 would allow certain 17-year-old citizens to vote. If a person is 17 years old and will be 18 by the next general election, they will be able to vote in the primary election and any special elections which occur prior to the next general election. A registered voter may run for elective office. So such 17-year-olds could run for elective office if they meet all other existing eligibility requirements for such elective office. The pro sides to this, it would be that it would allow first-time voters to participate in the full election cycle, provided that they are 18 by the time of the general election. This measure is needed to boost youth civic engagement in our elections, more lifelong participants in the most fundamental process of the democracy. It also engages people at a very young age so that they are on this lifelong journey of voting, one of the most essential factors in the democracy. And we also feel like they have a very important voice, one that we are hearing a lot of them from already. So it would be good to be able to have them vote. On the con side, science and legal consistency demand a no vote on Proposition 18. Law prohibits younger teens from smoking, drinking, and even tanning because research shows the logic and reasoning area of their brains are not fully developed. Those abilities are vital to responsible voting. We must not lower the voting age, keep it consistent. There's also a feeling, opponents are saying that if you allow them to vote in primaries on tax issues and debt issuance, it's not right because they haven't paid taxes and they really could be biased by people who influence them, whether it's their parents, aunts and uncles, teachers. They need more life experiences before they are ready. And schools could persuade 17-year-olds to vote one side or the other by pulling up posters or having teachers advocate only for certain policies. There are 18 other states that allow 17-year-olds to vote. There are, in California, about 500,000 people, young people turn 18 every year. And there is really not much organized for or against this in terms of dollars being spent. Any questions?
No questions.
Okay, we're going on to number 19, Renee.
Proposition 19, changes in property tax rules. It's another legislative constitutional amendment. Should the California Constitution be changed to modify the rules for transferring property tax assessed values and use any resulting new tax revenues for efforts, schools, and local government? Currently, some homeowners who are over the age of 55 have a severe disability or whose property has been impacted by a natural disaster are allowed a once-in-a-lifetime transfer of the taxable value to a different home of equal or lesser value. Transfers must occur within 2 years, and there are 10 county governments allowing transfer of taxable value between the counties. So you don't have to just be in this county, you can transfer to another county. When principal residents are inherited by adult children or between grandparents and grandchildren, the heirs inherit the original owner's lower property tax assessment. That's the current. The proposal, Proposition 19, would allow eligible homeowners to transfer a property's taxable value to a more expensive home anywhere in the state up to 3 times in a lifetime. It would allow once in a lifetime transfer for victims of wildfires and natural disasters. It would eliminate the transfer of taxable values of inherited properties unless the properties are the heir's principal residence or a farm. It provides an upward tax assessment adjusted for inflation after February 16th, 2023 to owner-occupied inherited properties with a market value more than $1 million greater than its taxable value. Would use increased tax revenues from Proposition 19 in a statewide fire suppression efforts and reimbursement of county costs. The fiscal effect, the overall impact would probably yield governments and school tens of millions of dollars per year. Over time, the revenue gains could grow to a few $100 million per year. Transferring lower property tax bills to a different home could reduce some local property tax revenues. However, revenue increases overall are expected in the tens of millions of dollars per year, reaching a few $100 million per year over time. Increased home sales could generate transfer tax and state income tax revenue expected in the tens of millions of dollars each year. The costs, state administration costs, are expected in the tens of millions of dollars each year. There could be some state cost savings where lower property taxes result in lower state matched school funding. Savings would be applied to, pardon me, savings would be applied to fire suppression efforts. The supporters of Prop 19 expands Proposition 13 rules for homeowners who are seniors, wildfire victims, or people with disabilities, allowing the transfer of their home's property tax value to replacement homes anywhere in California. It closes tax loopholes on inherited properties not used as primary residences, directing increased tax revenue to fire protection, schools, and local governments. The supporters have raised $40,700,000, almost $800,000. And the primary supporters of this are the California Association for Realtors, California Professional Wildfire Fighters, and the San Diego Union Tribune. The opponents for Proposition 19, the California Constitution was amended 3 times to protect the right of families to pass their home and up to $1 million of other property to their heirs without changing Proposition 13 tax assessment. Reassessment to market value will force families to sell their property because they cannot afford high property taxes. And money raised by the opponents is $45,000. And one of the major opponents is the Howard Jarvis Taxpayer Association, the California Business Roundtable, and the Los Angeles Times. A yes vote means all homeowners who are over 55 or who meet other qualifications would be eligible for property tax savings when they move. Only inherited properties issued as primary homes or farms would be eligible for property tax savings. A no vote means some homeowners who are over 55 or who do not meet other qualifications would continue to be eligible for property tax savings when they move. All inherited properties would continue to be eligible for property tax savings. Any questions?
There are no questions on the chat.
Thank you.
All right, thank you. We're going to go on to 20. Proposition 20 restricts payroll for certain, I'm sorry, we'll start again, and this time I'll do it correctly. It restricts parole for certain offenses currently considered to be nonviolent, authorizes felony sentences for certain offenses currently treated only as misdemeanors, and it's an initiative statute. The question is, should California law be amended to make changes to the process by which people are charged with certain crimes and the process for granting them parole? Right now, AB 109, Proposition 47, and Proposition 57, all three of them were intended to reduce the state prison population as ordered in district court and upheld by the U.S. Supreme Court. These measures have brought the overall state prison population below 137.5% of capacity, but many individual prisons are still operating above that percentage. Proposition 20 would make several changes. One, certain theft and fraud offenses that were made misdemeanors by Proposition 47 and new categories of serial crime and organized retail crime would become wobblers. That's spelled WOBBLERS. And a wobbler means they could be charged as misdemeanor or they could be charged as a felony. Proposition 20 requires the collection of DNA from people convicted for a variety of crimes, including some crimes that were redefined as misdemeanors way back by Prop 47. Proposition 20 creates a list of criteria for the Board of Parole hearings to use in considering whether to grant parole to an inmate convicted of a non-violent crime. It would allow prosecutors to review information about the inmate and to review the board's decision, and it would allow victims' families to participate in parole review. Prop 20 expands the list of crimes classified as violent crimes, and Prop 20 makes changes to the information provided to local officials when a person is released to supervision, and requires that counties request parole or probation be revoked if the terms of post-release are violated for the third time. The fiscal effect, the costs are difficult to estimate, but because it would result in an increase in the prison population and change the way post-release supervision is handled, Prop 20 would increase state and local costs by tens of millions of dollars annually. The supporters say that Prop 20 reclassifies certain crimes like assault with a deadly weapon, date rape, and child abuse as violent, that it would not increase the prison population, that it would only ensure that people convicted of these crimes serve their full sentences, and that it will help stop car break-ins, shoplifting, and other theft that has been on the rise. The opponents say that Prop 20 will roll back prison reforms and cost taxpayers millions of dollars annually, that it slashes mental health and rehabilitation programs that help to prepare people for release from prison and reduce repeat offenses, and that it will result in extreme sentences for petty theft and will disproportionately impact vulnerable minorities. Now, the supporters have raised over $401,000, and the opponents have raised $6,478,877. And the supporters for the change are the Republican Party, U.S. Representative Devin Nunes, and the Association for Los Angeles Deputy Sheriffs. And the people opposed to it are the Democratic Party, former Governor Jerry Brown, and the California Labor Federation. A yes vote means people who commit certain theft-related crimes could receive increased penalties. Additional factors would be considered for the state's process for releasing certain inmates from prison early. And law enforcement would be required to collect DNA samples from adults convicted of certain misdemeanors. A no vote means penalties for people who commit certain theft-related crimes would not be increased. There would be no change to the state's process for releasing certain inmates from prison early, and that law enforcement would continue to be required to collect DNA samples from adults only if they are arrested for a felony or required to register as sex offenders or arsonists. And that is Proposition 20. Jean, do you have any questions?
No, there are no questions asked.
All right, then we're going on to 21, and I'll
me.
figure this out.
It's me.
And Ruth is going to do 21.
Okay, Prop 21 expands local government's authority to enact rent control on residential property. If this seems familiar, it's because it is familiar. We voted on something that was essentially the same 2 years ago, and it was defeated. And so it's been brought back for a redo. The question is, should current state law be changed to allow cities and counties to apply rent control to housing 15 years old or older and limit rent increases to 15% once a new renter moves in? So this is billed as a rent control ordinance, but it is not. All it does is it allows cities and counties to enact rent control when they are currently prohibited from doing so. And the reason they're prohibited from doing so is that in the 90s, early 90s or late 80s, the legislature passed something called the Costa-Hawkins Rental Housing Act. And that basically grandfathered all current rent control ordinances and said they're okay, but it cannot be applied to any single family homes or any newly built housing since 1995. So basically, it is eliminated all more rent control. We don't have a lot in Southern California. Los Angeles has a rent control law and Santa Monica does, but none of the other communities do. There are about a dozen communities, most of the rest are in the Bay Area, that do have it. But right now, cities and counties aren't allowed to enact new laws. And we are, as everybody knows, in a housing crisis. And this is intended to address that. So it would reduce the limits on local rent control laws in Costa-Hawkins so that cities and counties can apply rent control to more properties. It doesn't, again, apply any rent control. It just allows cities and counties to do that. So the supporters say that even small increases in rent forces more families into homelessness, which is part of our housing crisis. Many seniors and veterans are left with too few resources for food, medical care, and other needs. And Prop 21 does guarantee landlords a reasonable profit. The opponents say that, again, more than 60% of Californians rejected this in 2018. It results in less available and less affordable housing, and it will stop new housing from being built. The changes would allow rent control to housing which is more than 15 years old, because that's the depreciation period in general, with the exception of single-family homes owned by landlords who own 1 or 2 properties. You know, if somebody owned a rental property that's different from a big company owning lots and lots of houses. So in terms of the money and the supporters, a lot of money has been spent on this proposition. $28 million has been spent in favor of Prop 21. Almost all of it is from the AIDS Healthcare Foundation, with a little bit from the California nurses. This is the same organization that supported the 2018 bill. They have apparently lots and lots of money to spend, and the executive board of that foundation believes that this is the best place to spend it on. It is supported by the LA Times, by Housing California, by the Democratic Party, the ACLU Sierra Club. If you thought that was a lot, the opponents have spent $56 million and change. And that comes from a variety of real estate operations, because it is not in their best interest. The California Business Roundtable has contributed 5.6%, Essex Property Trust 6.8%, and a lot of other real estate interests. A lot of veterans groups are, despite what I told you a little while ago, are opposed to this, and the building unions are also opposed to it for obvious reasons.
I do have a question on that one.
Yeah.
That is, how does this work with what the governor just signed, limiting rent increases?
Okay, yeah, and that's interesting, because I've been seeing those ads too. Though that limits rental increases for certain properties, but it doesn't address some of the other issues that are addressed in here, in terms of when somebody moves out and somebody moves in. I looked, because I saw those ads, to try to see whether Gavin Newsom is on the list of opponents. He's not on the Voters Edge site, at least. I don't know whether he actually is. The ads say that he is. The LA Times editorial did address it a little bit and said that it has made, what the governor signed has made some changes, but it doesn't go as far as this does. And again, this doesn't do anything. All it does is allow cities and counties to do it, and then you can address your elected representatives in those cities and counties to decide whether or not you want to do that or not.
Thank you.
Anybody else? Okay, then Ruth is going to go on and do 22.
Okay, 22. Oops, I went to the wrong page. 22 exempts app-based transportation and delivery companies from providing employee benefits to certain drivers. And if you want to know what an app-based transportation and delivery company is, it's Uber or Lyft or DoorDash or any of the delivery companies that have sprung up in recent years. So the question is, should people who work for those companies, who drive for those companies, be classified as independent contractors rather than employees? And should rideshare and delivery companies be required to adopt labor and wage policies unique to these drivers? So the way they've been set up is these companies have said, we're software companies. We're not real companies. And so that the people who drive for us are independent contractors. And as independent contractors, the company doesn't have to provide benefits for them. They don't have to provide unemployment insurance. There's a number of things like that. So in 2019, the California legislature passed a law, AB 5, which limited the ability of companies to hire workers as independent contractors. They said they're really employees. They are working for the companies and so on. So they're classified as employees rather than independent contractors. The companies do not like that decision. And so the idea of this, and this would be an initiative statute, is it basically would repeal AB 5 and reinstate these employees as independent contractors. So the proposal reclassifies them as independent contractors. There would be some minimum compensation. They would require the companies to pay at least 120% of the minimum wage for each hour spent driving. Well, you know, they're not driving constantly, but it would be for each hour spent driving. They would provide a subsidy for them to buy health insurance with. They would not provide health insurance for these people, but they would give them some money to purchase it. And I don't think it says how much that would be. They would require the companies to buy insurance to cover medical expenses when a driver is injured while driving. Right now, the drivers are required to buy their own insurance, and that's an issue because the auto insurance companies then don't want to have it covered as personal. They want it covered as business, and that costs more money and so on. And there would restrict drivers from working more than 12 hours a day for a rideshare or delivery company. And there would be some other things about workplace discrimination and sexual harassment policies and so on and so forth. They'd have to conduct criminal background checks. And it would also prevent cities, you know, any of our local cities from enacting a statute that's more restrictive. So the fiscal effects it would be lower costs and higher profits for rideshare and delivery companies because they wouldn't have to provide benefits and all the other things that companies normally do. And it says drivers and stockholders would pay more income taxes, presumably. So the supporters say that classifying drivers as employees would lead to longer wait times, higher prices, and less access to rideshare and delivery services. And it would improve delivery and rideshare work by providing these extra things that are included in the law. Opponents say that Prop 22 would eliminate basic workplace protections and replace them with lower guaranteed earnings and healthcare subsidies to save costs for the company. And this says a majority of drivers do work 30 or more hours per week. So a lot of money has been spent for this. In favor of it, $186 million has been spent to get this passed. 51 million from Uber, 48 million from Lyft, 47 million from DoorDash, some from Instacart, Postmates. You can get that. Business groups support this. Republican Party supports it. Interestingly, many NAACP chapters support it. The opponents have spent or raised just under $14 million, which is a lot of money, but it's not 186 million. The people who are opposed to it, the Teamsters, you can understand they're drivers, unionized drivers, so they're opposed to that. And some SEIU unions, each about $1 million. The opposition is the Democrats, the LA Times. A couple of interesting things. The LA Times says, and I think they have, I'm not supposed to express my opinion, but their point is that these drivers are really not independent contractors and they're really not employees. There's something in between. And there may be a third way that needs to be developed. It hasn't been yet. And so they're saying vote no, so that maybe that gets done. The other thing is there were a couple of organizations that were listed in the opposition who I clicked on because they had interesting names. And what it did was it took me to a page that had prominent pictures and quotes from Joe Biden, Kamala Harris, and Elizabeth Warren on it, opposing it. And you wouldn't have guessed that from the names, but I was just kind of curious about these names. It was like Gig Drivers Unite or something like that. And it took you to this page. So those are also opponents to this proposition.
Jean, are there any questions?
No, I don't see any questions on this one.
All right, we're going to go on to 23. 23 establishes state requirements for kidney dialysis clinics, requires on-site medical professional, and it's an initiative statute. And the question is, should outpatient dialysis clinics be required to have a physician on site at all hours when patients are being treated, offer the same level of care to all patients regardless of their insurance or non-insurance, and report infection-related information? And if you think you've deja vu, it is. It was here 2 years ago, almost exactly the same. These clinics are licensed by the California Department of Public Health using federal certification standards which have limited requirements about staff, hours, or ratios. Federal law requires one physician visit per patient a month. The majority of the 600 licensed clinics are owned and run by one of two private for-profit companies. Proposition 23 says that clinics must have at least one licensed physician on site during all hours when patients are receiving treatment, that clinics must offer the same level of care to all patients, regardless of whether treatment is paid for by private insurance or a government program, that clinics must report more information about infections among their patients to the state health department with penalties for non-reporting, and that clinics notify and obtain consent from the state health department before closing or reducing services. Now, the fiscal effects is that Proposition 23 could increase the cost for the clinics because a licensed physician would have to be present. This could average several $100,000 per year per clinic. And Proposition 23 could increase healthcare costs to state and local governments in low terms of millions of dollars annually because they would have to raise their rates. The supporters say that patients should have access to a physician on site whatever dialysis treatment is being provided, and that proper reporting and transparency of infection rates encourage clinics to improve quality, and that strong protection should be provided to vulnerable patients when clinics close. And the opponents say that Prop 23 would force community dialysis clinics to cut services or close, putting lives at risk, that it would make our physician shortage worse and lead to more overcrowding in emergency rooms, and that dialysis clinics are already strictly regulated and provide high quality care. Now, the supporters have raised over $6 million, and the funds raised against it are over $93 million. And the supporters, most of the money has come from SEIU, which is the Service Employees International Union, United Healthcare Workers West. And they've put in almost 6 million. And the opponents have put in, most of them are coming from clinics like DaVita or another one called Fresenius Medical Care. The California Democratic Party is in favor of it. And the Los Angeles Times editorial board is against it. A yes vote means chronic dialysis clinics would be required to have a doctor on site during all patient treatment hours. And a no vote means that chronic dialysis clinics would not be required to have a doctor on site during all patient treatment hours. They would just continue as they have been working up until this time. No questions?
No questions.
All right, then we're going on to 24, and Renee is going to do 24.
Proposition 24, it amends the consumer privacy laws. It's an initiative statute. Should an existing law from 2018, the California Consumer Privacy Act, be amended to increase penalties on companies that fail to follow regulations, to allow consumers more easily to opt in and out of sharing their data, changes criteria for which businesses need to comply, and creates a new enforcement arm that would cost about $10 million annually. Currently, the Consumer Privacy Act brought consumer protections, especially in helping them identify what kind of data were being collected. The current act affects businesses which earn more than $25 million in annual revenue, buy, sell, or share data from 50,000 individuals, devices, or households, and earns 50% or more of their annual revenues from selling personal data. Proposition 24 would change the following. It would raise the threshold so that only businesses that buy, sell, or share data from 100,000 individuals or households are subject to the rules. So that increases the threshold. Consumers could direct businesses from each website not to use their personal data for purposes other than the delivery of the actual services the consumers were buying. They could also ask for data corrections. Violation of a minor's privacy rights would mean a fine of $7,500. That happens to be triple the current fine. Proposition 24 would mandate immediate penalties for a data breach. It would also create a new California Privacy Protection Agency, which would take over some enforcement functions from the Department of Justice. The fiscal effect, Proposition 24 provide $10 million, about $10 million annually from the general fund adjusted over time to finance a new agency. State costs to the Department of Justice and trial courts probably wouldn't exceed the low millions annually. Fines might offset these costs. The supporters for Proposition 24 would support because they believe it will prevent businesses from using or sharing sensitive data about your health, finances, race, ethnicity, and precise location. That it would strengthen existing protections by establishing a California Privacy Protection Agency with $10 million a year. And by virtue of being a ballot initiative, it is less vulnerable to watering down through the pressure that lobbyists put on legislation. The opponents for Prop 24 says that it puts the burden on the consumers to opt out of countless intrusive data collection practices, one by one. I'm sorry, that wasn't clear. They would have to opt out for each company, each part, wherever their data was being collected, they would have to opt out one by one. And hidden economic discrimination persists. People without money to spend cannot pay for loyalty programs and can expect worse connections, slower downloads, and more pop-up ads if they opt out. Proposition 24 would also allow employers to keep gathering data about things about their employees, such as pregnancies, religion, or political activism. So the supporters of this initiative have spent $5,547,141, and that was raised in most part by one person, Alistair McTaggart, who is a real estate developer in San Francisco area. He put in $5,533,524. So most of the money came from him. The total raised by the opponents was only $48,000. And the two top contributors for the opponents is Consumers Federation of California and the California Nurses Association. A yes vote means existing consumer data privacy laws and rights would be expanded. Businesses required to meet privacy requirements would change. A new state agency and the state's Department of Justice would share responsibility for overseeing and enforcing state consumer privacy laws. A no vote means businesses would continue to be required to follow existing consumer data privacy laws. Consumers would continue to have existing data privacy rights, and the state's Department of Justice would continue to oversee and enforce these laws. Any questions? Jean?
No questions have been submitted.
Okay.
Thank you.
We're going on to 25, and Terry's going to do 25.
Yeah.
Terry, we can't hear you.
Better. Proposition 25 is a referendum on the law that replaced money bail with systems based on public safety and flight risk. So the question is, should the law enacted by the California legislature to replace the current money bail system be approved? Before we go deep into that, the fiscal impact of this is, it could be a trade-off. There is a new system that would have to be built if they get rid of the cash bail, but there could also be less people being in jail held because they can't make the cash bail. So there's going to be some trade-offs there. What happened in 2018 was that the legislature passed SB 10, which would do away with the money bail system so that people arrested or arraigned in court might not have to post bail in order to stay free pending in their trial. SB 10 did not go into effect because the referendum was filed. Our state constitution provides people arrested and placed in county jail have the right to release before their trial. The trial courts must consider, one, the seriousness of the crime involved, the person's prior criminal record, as well as the likelihood of the person appearing at court for the trial. In some instances, a person can be released from jail before trial just on his or her promise to appear at the trial. In other instances, the person must provide a financial guarantee that he or she will appear. In those cases, the person can put up their own assets as the financial guarantee to be returned when he or she shows up at the trial, or the person can arrange for a bail insurance policy to provide the financial guarantee. Bail insurance companies charge non-refundable fees to provide these financial guarantees. Proposition 25 would allow SB 10 to go into effect. SB 10 would eliminate cash bail, and the legislation would replace the cash bail system with risk assessments to determine whether a detainee suspect would be released before their trial. Instead, the law gives judges wide discretion to decide who can be released prior to trial. Defendants deemed to be a danger to the community could be held under a policy known as preventive detention. Different suspects would be considered low risk, medium risk, or high risk. And then the judge would have, would be able to keep some in jail, release those potentially that were low risk. What supporters say is that if we replace money bail with a fairer, safer, and less costly process, a person can't afford to pay bail bond company, they go free until trial. If they can't afford to pay, even if they're innocent, they stay in jail. And that's discrimination against those that are not as wealthy or can't make that bail. If you are opposed to this, Proposition 25 was written by Sacramento politicians to take away every Californian's option to post bail and replace this right with a new discriminatory system of computer generated profiling administered by government bureaucrats, costing taxpayers hundreds of millions of dollars. I did not find substantiation for that, even though that has been stated. The opponents say that SB 10 intentions are good, but the provisions may effectively result in more people being jailed than under the current situation. If you're wondering who actually came up with this referendum, it was the bail bond people, American Legion, Peace Officers Association, but the bail bond people whose businesses are at risk have been spending a little over $6 million to try to get this opposed, because then nothing would change. But in order to, if you vote yes and the cash bail system is gone, we have Connie and Steve Ballmer have put quite a bit of money into this. The League of Women Voters is supporting it, the SEIU. There are numbers of almost $12 million supporting that this piece of legislation goes forward to get rid of the cash bail.
Just a reminder that this is, again, to reiterate what Terry just said, that this is a referendum and the law is not in effect because it was challenged by this group. And so the law is sitting, waiting there. And the referendum seeks to overturn this law. And so it's a reverse on how you normally would vote. Okay, so be careful of this one because it changes the way we usually look at how we vote for things.
Barbara, that doesn't seem to be the case here.
What doesn't?
At the bottom of our pros, and cons, it says a referendum asks whether you want to approve or reject a law passed by the legislature. A yes vote means that you approve the law, and a no vote means that you reject the law.
Yeah, it gets complicated here.
Yeah, but I mean, that's the same thing. If you agree with the law, you vote yes. It's not reversed, which I thought it was.
Yeah. So yes, you want it to go into effect. No, you do not want it to go into effect. Are there any questions?
We do have a question. How many other states have laws like this?
I don't know the answer to
I don't
that.
know the answer to that.
Terry, do you know the answer to that?
I don't. Usually it's brought in several of the other propositions where a lot of people had it already, 10 to 20, it was stated in the information that I had been reading, but there was nothing written about.
I didn't see it either.
I want to make one comment. I've been seeing commercials on TV that, again, the NAACP opposes this because they said the algorithms which would be used to determine whether somebody qualified for cash bail or for release or not are probably going to be discriminatory against minorities.
But
on proper history.
But Ruth, what I found, they don't have a system yet. So how can they say that?
Well, I think in other instances, the algorithms, somebody, when you develop software, somebody is making the decision about what, how you do it. It's the same thing with driverless cars. Somebody is making the decision about what's going on, and based on prior history, when people do that,
because
I need to ask Joan a question. Joan, I have 8:27. The second group is coming on at 8:30. Am I correct?
Yes.
So we're going to need to stop now. Is that correct? I can't hear Joan. Would someone unmute Joan?
She should be able to unmute.
Terry, can you do Jay in 3 minutes?
Not to do it justice.
Okay, then let me end with telling everybody that October 19th is the last day to register, and online at registertovote.ca.gov. And you know that November 3rd is the election. You can register to vote and get a provisional ballot on November 3rd. The drop boxes are picked up every 72 hours. And the last week they'll be picked up every 24 hours. And be careful of those make-believe drop boxes. The drop boxes in our communities are written on your ballot, so you will see where they are. And just the last minute thing that you probably don't need, that be aware of the statements that we read to you from supporters and opponents, because we're just reading what they said without making judgments on it. And same thing for the ads and commercials and junk mail. No matter how I believe on the propositions, both sides are lying. I figured that out. So I don't trust any of them. And they believe that they're there to influence your vote, and they're not fact-checked. So be careful of that as well. Last thing is, if you have any voting questions, and you cannot get through to the registrar, if you will call our phone number. If I can't get it, I now, as of today, have a contact at the registrar and can call him directly to find out. So,
one last thing, somebody asked about cash bail. It says, as of January 2020, 3 states have abolished cash bail. I can only see 2 of them on my phone so far. New Jersey and Alaska are 2 of them. I don't know what the third one is.
And my last thing is to thank both Jean for handling the questions, and Ruth and Terry, who are on the league board, and a special thanks to Renee, who is a new member and has taken this big jump and volunteered to do this tonight. So thank you to all of you.
And to remind everybody that if they're interested in the positions that the league has taken on these propositions, please sign into the second number that was on the notice that you got. So this will end and you have to sign in again. The righties?
Thank you, Jay. We don't have any J's. I don't have a J on my ballot. We all have J's or not?
We should.
Yes, it's a county measure. You should have it. Look it up again. It's not one of the 12. It's the 12 of the state, and J is the county. It's there. And if you can't find it, give me a call and I'll ask my contact why they didn't put it there.
They're
near the beginning.
Yeah, it's near the beginning.
If you're voting by mail, the clerk and recorder will tell you how you signed your name. I didn't know whether I used my initials or my name. I got an answer within 10 minutes.
You got lucky.
Okay, thanks, everybody.
Okay, I'm gonna end this meeting now and then we'll start the next one.